Welcome. Constitution and constitution making. A constitution is a body of rules from which the laws of a state or country are derived. Functions of a constitution. It provides a legal framework upon which the laws of a country are drawn. It spells out the duties and the functions of a government towards the governed. It defines the duties and the responsibilities of the citizenry. It spells out the functions and the powers of the arms of the government and their relationship. It is a yardstick for measuring the performance of a government. We have two types of constitutions. We have the written constitution and the unwritten constitution. Features of a written constitution. They are documented, easily available for reference, cannot easily be changed or altered. A precise procedure must be followed for amendment. Certain provisions have safeguards, making them unalterable, e.g. Bill of Rights. They contain the fundamental liberties of the individual. They spell out the functions, powers, and the relations between the different organs of the state or organization. Advantages of written constitutions. The documents are available for reference. They provide guidance to new or young nations. They foster unity in multi-ethnic societies since the people rely on the constitution for the legal framework. They preserve or maintain the interests of the minority. All communities present are given equal treatment before the law. They cannot be changed by those in authority to satisfy their personal interests. Disadvantages of written constitutions. They do not change with the emerging trends in the society. Hence, they tend to become redundant. The phraseology is rarely understood by the ordinary citizens. They invite disputes and disagreements during interpretation. Amendments tend to be slow, cumbersome, and constrictive because certain conditions have to be fulfilled. It is too expensive to overhaul due to the multiplicity of interest groups. Advantages of unwritten constitution can be changed by an ordinary legislative process, for example, by the parliament. They are well suited to the needs of the people since they are indigenous. They are flexible, therefore they can be adapted to the new developments in the society. They are subject to broad interpretations. Disadvantages of unwritten constitution. They give too much work to the courts while handling judicial matters. This is because legal information has to be sought from many different sources. It is difficult to protect the rights of the people because the fundamentals exist in many documents. They can easily be manipulated by those in power to satisfy their interests. They are not suitable for young nations. The Independence Constitution of Kenya. This is the constitution that was adopted at independence. It provided for a coalition government between KANU and KADU. It provided for a federal government with 6 regional governments. It provided for the post of a Governor General as head of state on behalf of the King or Queen of England. It provided for the position of a Prime Minister as head of government. It provided for a bicameral National Assembly, for example, the Senate and the House of Representatives. It provided for the Bill of Rights, that is, the alienable rights of the individual. It protected the interests of the minorities, that is, the small African ethnic groups, Europeans and Asians. It provided for a multi-party democracy. It gave the judiciary the powers to interpret the law. It provided for a judicial service commission to ensure the independence of the judiciary. It provided for a public service commission to cater for the appointment, discipline, and dismissal of civil servants. It provided for the creation of an independent electoral commission whose duties were determination of constituency boundaries, supervision of voter registration, and to conduct elections. Features of the Kenyan Constitution. There is separation of powers between the executive, legislature, and judiciary. The rule of law, that is, all Kenyans are bound by the same law. Recognition and protection of individual human rights and freedoms. A unitary government. Multi-party democracy. Gender equality can only be changed with the approval of Parliament. The constitution making process in Kenya. Number 1, there is civic education. Number 2, writing of reports by the C.R.E, that is Constitution of Kenya Review Commission. Printing, publication, and circulation. Number 4, feedback. National Constitutional Conference. Referendum. Then presentation to the Attorney General. And at last, presidential assent. Constitutional amendments in Kenya since independence. In 1964, Kenya became a republic with a unitary government headed by the executive president. And the powers of regions were abolished and the former regions became provinces headed by provincial commissioners. In 1965, a two-thirds majority of the House was required to approve any proposed constitutional amendments for adoption. In 1996, the two houses of parliament amalgamated to form a unicameral one parliament. In 1996, an MP who resigned or defected from the party that sponsored him or her to parliament would automatically resignation. The MP would then seek fresh mandate from the electorate on his or her own new party ticket. In 1966, through the Public Security Act, the President was empowered to detain people without trial, control the movement of people, and censor the press to safeguard the security of the state. 1968, the President was empowered to authorize changes of administrative boundaries, a power previously enjoyed by Parliament. Still in 1968, through the Presidential and National Assembly Elections Act, the President was to be elected directly by the electorate rather than an electoral college after nomination by a political party. The President was authorized to postpone elections to the National Assembly. The Constitution was amended to allow the Vice President to assume presidential powers in the event of death or incapacitation of a sitting president. General elections were to be held within 90 days to elect a new president. In 1974, the minimum voting age was reduced from 21 to 18 years, The minimum age of a presidential candidate was lowered from 40 to 35 years of age. 1975, Kiswahili was declared the official language of the National Assembly in addition to English. The president was empowered to pardon election offenders. 1977, the Kenya Court of Appeal was established to replace the East African Court of Appeal. English became an alternative to Kiswahili as national language in the National Assembly. Proficiency in both became mandatory for aspiring parliamentary candidates. 1979, the Elections and Public Servants Amendment Act provided for the resignation of public officers who wished to vie for parliamentary seats 6 months to the election date. 1982, Kenya became a de jure by law one-party state. That is, Kenya became a one-party state. All other political parties were banned forthwith. 1987, the security of tenure for the Attorney General and the Controller and Auditor General was removed. 1990, the repeal of Section 2A of the Constitution ushered in a multi-party democracy. The security of tenure of Attorney General and Controller and Auditor General was restored. 1991 limited the tenure of the President to 2 5-year terms, that is 10 years. 1997 allowed the nomination of MPs to Parliament by political parties on the basis of their share of elected seats. Did you understand? Kindly let me know in the comment section below. And also let me know what video to look at tomorrow. Thanks a lot for subscribing and listening to me. God bless you.